Why would a administrator or broker proactively tell them, hey, Susie, I got something to tell you. If you do deny a claim at a final level appeal and the hospital or the patient, whoever sues, your name's in the paper. Your company's name is in the paper. Now, it's one thing if it's Google, right? But again, we're talking about self-funding with the captive or self-funding with an administrator. You probably have one main location. You're in Poughkeepsie. And the hospital that the kid went to was Poughkeepsie Regional.
Yeah.
And Poughkeepsie Regional now, and this patient is potentially suing the employer for not paying the claim. What do you think the local news looks like?
Welcome to Captivating Health Insights. We are back with a bonus episode with Adam Russo again of the Phia Group, and we're talking about fiduciary responsibilities for self-funded employers. Welcome back, Adam.
I can't believe you guys actually want me back.
We do. Yes, it's unbelievable.
Something's in the water here, I guess, but it's great to talk a little bit more. And, you mentioned fiduciary responsibility.
Yes, I feel like this is a huge topic. I don't hear about it enough. I mean, we definitely need to understand. So why do self-funded employers need to understand that they are a fiduciary of their health plan?
So I'm going to tell you a story.
Okay.
12 years ago, I'll never forget this day. I'm sitting in a room, and I'm going to try to use some props. All right, so
okay, we got coffee cups. Okay.
You are the administrator, the TPA.
Okay.
That cup is the broker. My cup is a stop-loss carrier, and I'm me. I'm Phia. Okay. And we're all on a call. And there's $1 million claim.
Okay.
The stop-loss deductible is $100,000. So most of the claim, if it was paid by the plan, has to be reimbursed by the stop-loss, right? So they pay $1 million on the claim, they'd reimburse $900,000 if their deductible is $100,000. Make sense?
Yes.
Okay.
Mm-hmm.
So what everyone's trying to figure out is, the administrator's trying to figure out, and the broker, if you pay the claim, if the administrator decides to pay the claim, because many claims, it's a gray area, right? There's some legal issue. Is that part of the claim excluded? Is it medically necessary? Is it experimental and investigational? All these things get into a claim. And most administrators and organizations don't have the clinical expertise or the legal expertise to make these calls. So we're all on the call. And the broker says, hey, TPA, why are you asking me if the claim is payable? You've been making the claim decisions for the past 10 years. You've never had me question a claim.
Yeah, you're the TPA.
You're the TPA. And the TPA goes, whoa, wait. If you read the administrative service agreement, it specifically says that we are just processing the claims. We don't decide whether or not to pay the claim, and they're correct. You know what decides whether or not to pay a claim? The SPD, the plan document, which, by the way, hasn't been updated in 2 years, which, by the way, has 75 amendments. Amendment 35 actually overrides Amendment 22, which is overridden by Amendment 62. So it's complex.
Yeah.
The broker thinks the TPA is supposed to make the decision. The TPA is telling the broker, no. It's your client, the plan, is the employer, is the plan sponsor. They make the decision. So what happens?
We got finger pointing going on.
And then both of you, the broker and the TPA, turn to the stop loss and go, hey, if we pay it, are you going to reimburse us? And the classic response from every stop loss carrier is, we can't make that determination until you decide whether or not you want to pay. And that's what they should say, because they don't have all the details yet. So I'm in this meeting on the call, and it's like an hour long. I'm getting paid an hourly rate. And all of a sudden, all three of them look to us and look at me. Hey, Adam, what do you think? Should we pay the claim? And I'm sitting there going, I'm not paid enough money to make this decision. And that's when it sparked. Ron Peck, who's my chief legal officer, who I think would also be a great guest for you guys.
Yeah.
He does stuff all the time. He's sitting next to me, and Ron and I said, we had a meeting right afterwards. And I go, this is a major pain point in our industry, and it's getting worse all the time. There's more and more lawsuits when it comes to claim denials. We'll get into that in a second. And Ron and I said, what if we take this pain point in the industry and instead turn it into a positive experience. Why don't we just make the claim decision? Why don't we become the fiduciary for the plan on only final level appeals? Remember, a final level, if you watch the first podcast, you would know the final level appeal is the last appeal before it can go to the outside world.
Yeah.
Right? In litigation. So we said is, we'll charge a small per employee per month fee. And if there's a final level appeal, the second one, we'll gather all the documents. We'll take all the clinical information, the plan document, all the notes, all the bills, all the doctor's records, etc. And we'll decide if that claim is payable based on the language in the plan.
So you're taking the fiduciary responsibility.
Just on the final level. Why? Why not all claims? Because most claims, there is no final level. It's 1 out of 100. But it's almost like purchasing insurance, right? Homeowners. You don't expect your home to burn down, but it could happen. Hence, you buy homeowners. You don't expect to be in a car accident tonight, but it could happen. You have car insurance. Same thing. So what it does, though, is before we agree to be the final level fiduciary, here's the best part. You have to qualify. How do you qualify plan to allow Phia to be willing to be the fiduciary on those claims? You have to have a compliant plan doc.
Okay.
So before this product was created, it's called PACE. Okay. Before the product was created, when I would go to an administrator and go, hey, my friend, by the way, yeah, all of your plans are illegal. You know what the answer typically would be? Thanks, Adam. I'll take that upon it. I'll take that. I'll take that
under
advisement. Thank you for helping me. Yeah, I'll take that advisement. But now, when I say we're not willing to be the fiduciary because your plan's not compliant, what's the next question? How much does it cost to become compliant?
How do I be compliant? Tomorrow? Yeah, I don't want that on my back.
Since we started that service, there are 2.5 million employees whose claims we are the final level fiduciary. And when we say it's a payable claim, that stop loss carrier, they're not questioning us. Why? We're an independent third party. We have no reason to push the claim as paid or to deny that claim. The TPA or the administrator or the broker might say, hey, deny it. We don't have the $100,000 even to pay it. Or we have to make a decision within 1 day because we have 30 days to make the claim decision on an in-network claim based on network contracts, right? So everyone has a reason to either pay or deny, whether it's financial or whether it's just process. We don't. So we've never had, knock on wood again, we've never had a single situation in 12 years where we have advised a plan to pay a claim that there was pushback from the stop loss carrier.
Gotcha.
And if there was pushback from the stop loss carrier and the claim goes to what's called an independent review organization, IRO, to actually analyze the claim, we pay the fee. The best part of this whole thing is when we get those claims, we have the legal expertise to decide if it's compliant with the law, and we have the clinical expertise to decide whether it's clinically, medically necessary. Is it experimental? Is it investigational? The problem that we have in our industry is people always look at the cost, right, of everything. Do you understand there's a very big difference when you get a clinical review on a claim? I have seen clinical reviews that are 2 pages long. I've seen clinical reviews that are 500 pages long. Fine. However, in most circumstances, as an attorney, one thing you learn is no matter how good of a lawyer you are, you need to have evidence to prove your case. And it's really hard to have evidence when you have a really shoddy, not well-written case management or review done by some of these review organizations who will say, hey, we'll do all your reviews in regards to medical necessity, clinical reviews. We'll do each one for $200. Well, just imagine how thorough it is for $200. By working with us, we pay for all those expenses. So a typical self-funded plan in our industry right now, working with an administrator, with a captive, it could be 50 people. But a typical self-funded plan has 250 people on the plan. We're talking about roughly a $2 PEPM expense, $6,000 a year. You never have to worry about any claim. It's a no-brainer.
Yeah.
And that's why it's grown so much.
Gotcha.
But what we have seen from a fiduciary standpoint, especially now, we talked about mental health, more appeals. more fiduciary potential liability. 1. 2, you have more complex claims, much more complex, which means it's harder and harder. It's not always just black and white. There is so much gray in our world that sometimes part of the claim is covered, parts not. It's getting harder. You have all these issues now with AI denials, where you now have software under 2 seconds making a claim decision on a particular person, and it could be life and death.
That's crazy.
And that's how it's done.
Yeah.
And those are the things that we're seeing pushback on. But the biggest problem that we see is that most employers have no idea that they're actually responsible for making the decision on whether or not to pay a claim. And I can imagine if most employers did know that, it would scare them a little bit to be self-funded. However, by working with the right stop-loss carriers, the right brokers, the right administrators, the right captive, right, like you guys, you can feel much better knowing that you were reasonable in your decision. And one of the easiest things to do is by having someone else who's a non-interested party help make those calls. So we see AI causing a big issue when it comes to this. But the biggest problem that we're seeing nowadays is there are more and more stop-loss carriers and MGUs in our industry than there ever has been before. Now, how do we know that? Again, we have reviewed every single MGU and stop-loss policy that exists in this country. I could, right now, I won't, but I could, list all 50, you could give me a list of 50 MGUs and stop-loss carriers, rank them from who reimburses based on the language of the policy, who will never reimburse a claim.
You could rank them 1 to 50.
Easy. Easy. And there's probably 5 or 10 at max that I would work with. But it's one thing to know the policy, what it says. What you're never going to know is what is the claim behavior within that organization. There are some stop-loss carriers and MGUs where they're trying to find a way to help you. Mm-hmm. They're trying to find a way to get that claim reimbursed. Mm-hmm. Unfortunately, most of our industry now is let's find a way to not pay the claim.
Yeah.
Or at least not timely. Let's delay it as long as possible. Why? There's more and more pressure on these MGUs and stop-loss carriers to not lose money.
Yeah, to be profitable. Yeah.
Do you understand that 5 years ago, not 5, let's go back. Do you understand that before the ACA, if you saw $1 million claim, like everyone would gather around the table, like, wow, look at that claim.
Yeah.
How is it $1 million?
What?
I see $100 million claims every day. Every day.
Wow.
Every single day there is at least, and we're not Blue Cross National. We're a little Phia Group, great people.
Yeah.
The number of claims, the growth and size of these claims puts more and more pressure on premium going up and more pressure to find ways to not pay things because it's getting so expensive. Yeah. So it's something that every employer should think about. It's something that every broker should be able to offer to their clients. And it's just a nice way to have some security knowing ultimately at the end of the day, that woman that works in your accounting department, her daughter's claims, do you really want someone in HR who works 20 feet away from that person making that final level claim decision as to whether or not their daughter is going to get access to care?
I don't think that should be happening now.
And that's one of the key things that happens when it comes to a self-funded plan and a final level appeal.
So what's the risk for an employer if they say they don't have the PACE, program with you, they are the fiduciary otherwise? What's the risk if something happens? Or they can even be named in a lawsuit now, right? Like I don't think most employers understand that. Like can be named as the HR person.
Yes, of course. And think about it. Why would a administrator or broker proactively tell them, hey, Susie, I got something to tell you. If you do deny a claim at a final level appeal and the hospital or the patient or whoever sues, your name's in the paper. Your company's name is in the paper. Now, it's one thing if it's Google, right? But again, we're talking about self-funding with the captive or self-funding with an administrator. You probably have one main location. You're in Poughkeepsie. And the hospital that the kid went to was Poughkeepsie Regional.
Yeah.
And Poughkeepsie Regional now, and this patient is potentially suing the employer for not paying a claim. What do you think the local news looks like?
Yeah.
You think the local news is saying that great company rightfully didn't pay the claim because of XYZ? They're going, a local employer is being sued by their employee, and they show a picture of little 6-year-old Susie. Her claim is not being paid, literally, and it's front page news.
And it's negligence or ignorance. I mean, because now it's a newer thing, right? You are a fiduciary. What are you doing? If you get audited, how are you proving that you did everything in your power to build the most compliant, beneficial health plan?
Right. And most employers, especially those that are captives or those that are new to being self-funded, have never had this issue before. They've never had to make the claim decision, right? That's why when you see all the negative news about insurance companies, those are fully insured carriers who are denying claims because it's their money at risk. It's not the administrator's money. It's not the broker's money. It's the employer's money at risk.
Yeah.
So you don't want that story in the news, in the media, and it's a really easy situation. So here's the thing. When you work with a TPA, most TPAs do not offer fiduciary transfer services. ASO markets, they do. But if you're working with a captive or you're a smaller employee that wants to have more creativity, more innovation, be able to customize, you want to work with a third-party administrator, right? Or with a captive. Hence, that fiduciary duty is yours. And it says it right there in the plan.
Do you ever see one broker is taking on that responsibility or the employer creating a fiduciary committee to kind of make sure that they're doing their due diligence internally if they want to take it on themselves? Do you see
Sure,
that
they could.
happening?
Of course. I see it happening with larger companies because, again, if you look at the numbers, for the cost of being able to outsource that, whether it's to Phia or some other organization, there is no other organization that exists that does it, by the way. We even have law firms that are self-funded that use us as the fiduciary. Law firms do. Ropes and Gray, as an example. Big law firm. They use us as the fiduciary.
Okay.
So you see larger employers have fiduciary committees, but they have 1,000, 2,000 employees where it makes sense financially to spend $50,000, let's say, et cetera, on that committee who's looking at maybe, 10 to 20 claims a year versus if you're 100 lives or 50 lives or 200 lives, what fiduciary committee are you creating that has any expertise to be able to make those decisions in the first place? You're better having someone like us make those decisions for you, tell you why, and then we have the reputation within the market to make sure those claims are reimbursed.
Gotcha. Yeah, I've heard some rumblings of even smaller employers like trying to get savvy and do that, but I'm just saying there's options, right? Obviously, you guys have a package and you make it easy and it's there, and then there's, if you want to maybe take the road less traveled, there's some options too. But at the end of the day, someone has to take that responsibility and you can't be ignorant of that.
Of course. So it's great that employers have options. And I agree with you. They have all these different options. The problem is I don't even think most of them know that this is a responsibility that they have to have.
Right.
And even when they are told, it's like everything else we've talked about. You tell them once, it's like my kids. How many times you have to repeat the same thing, right? Goes in one ear, out the next. Yeah. And it's the same thing. So you're right. Fiduciary breaches are on the rise. The duty, it's a lot more complicated to be a fiduciary, but people have to know that they are one, not to take it lightly, and that there are different options available to help protect them.
Yep. Awesome. Anything else as we wrap up this really important topic? And that's why we're talking about it, because most people don't know about it. It's newer. Anything else as we wrap up, Adam?
Feel free to go on our website, phiagroup.com, and you can see everything about fiduciary transfer, fiduciary responsibility, options that you can have, and just sharing information. And I thank you for bringing up a topic that, it's not the coolest topic, right? It's sort of scary a little bit. And, if you're a salesperson, you don't really want to talk about it too much because you don't want to scare away potential clients. But it's a powerful thing that you could do right. You could do right with it. It's just important that you're aware of it and you have a process to deal with it if you ever had a breach.
Yep. Well, thanks for coming back for the bonus episode. Appreciate you being here, Adam.
Great to be here. Thanks again.
Thanks.